Hello, and thank you for joining us today for our legal update heading into 2025. We're joined today by John Gilbert. He has been practicing law since 1975, bringing us a wealth of experience representing some of the largest companies in the United States to the firm's Edwardsville office. John is a member of the Business and Business Litigation practice groups and focuses his practice on labor and employment, commercial and higher education law, as well as civil rights defense and correctional medicine. John serves as the team leader of the correctional medicine industry team at Sandberg Phoenix. When working with clients, John dives in headfirst, getting to know all about the client, their business, and the environment in which they operate. He's dedicated to first listening to his clients and working with them collaboratively to achieve their goals. John's favorite hobby is reading, especially mystery novels and academic publications about ethics and business. John, thank you for being here today. I know a lot of people are anxious to hear all of the topics you are expected to cover heading into 2025 and make sure we're ready for this new year.
Thank you, Summer. I appreciate that nice introduction, and we have a lot to cover this morning. I want to thank Higher Level for inviting me to present the webinar. Higher Level is a wonderful company and just great folks to work with. I do need to, for ethical purposes, indicate to all of our listeners that this presentation should not be considered legal advice. If you have legal questions related to labor and employment law, please consult your counsel, which I am happy to serve as, by the way. So I appreciate that, and we'll get started because we have a lot to cover. You know, the legislatures and Congress never stop legislating. And I used to practice before a federal judge who had a saying on his wall that said, our rights are most in danger when the legislature is in session. And many of my clients believe that. So we'll start out with what's happening. Whoa, sorry. I got ahead of myself here. With what's happening with non-compete agreements. There's a lot going on. As most of you know, the states have been legislating in this arena. There's hostility toward non-compete agreements. There are many business justifications for non-compete agreements, but state legislatures are becoming hostile. State executives are becoming hostile. So we now know from last year, the FTC barred all non-compete agreements. Currently, we have split decisions in the courts with regard to whether or not the FTC exceeded its legal authority in enacting this rule. So while it did take effect in September, we are watching the court cases, and eventually, I'm assuming it'll get to the Supreme Court, don't know for sure, but it's percolating through the courts, but it behooves all employers to pay attention to their state laws as well as the status of this FTC rule as it percolates through the courts. There's also a question of whether or not the rule will be rescinded under the new Trump administration. We don't know. But I would urge everyone to keep an eye out, talk to your lawyers, and pay attention to where they are. I know that here in Illinois, we have a statute that prohibits non-competes in certain circumstances, so you need to be alert for that as well. The NLRB, the National Labor Relations Board, which has been extremely active under the Biden administration, primarily in reversing Trump-era precedents, and then again, we'll see how that works out with the new administration. The board ruled that non-compete agreements violate the National Labor Relations Act in certain circumstances, in most circumstances. So again, getting into a deep dive on this is beyond our brief here, but the NLRB has weighed in by saying that non-competes might very well, in most circumstances, violate the NLRA because it interferes with the rights of employees to seek employment, to improve their status. The NLRB considers these types of agreements as coercive with economic impact to take away options of employees. And most recently, a couple of weeks ago, actually, the board ruled that stay or pay, should be stay or pay, sorry for the error there. Stay or pay agreements may violate the NRA, which is a big deal because many employers have programs under which employees who receive training, for example, or sign-on bonuses that are forfeitable. And the typical situation is where you pay for training for an employee and you have a stay or pay agreement, which means that if they leave within a certain period of time, they have to pay back the cost of the training on a pro rata basis or however the agreement presents it. Well, the NLRB a couple of weeks ago held that stay or pay agreements may violate the NLRA because, again, they foreclose options for employees to essentially better themselves or be competitive in the marketplace. And by virtue of that and the financial penalties that these stay or pay agreements provide are coercive in the workplace. For example, an employee might want to seek employment elsewhere or seek to improve conditions at his or her place of employment, but a stay or pay agreement keeps the employee from, at least according to the board reasoning, may keep an employee from fully exercising his or her Section 7 rights under the NLRA, and it has a coercive effect in the workplace. So again, these are most likely to be challenged in court, but right now it's what we're dealing with. So you need to get advice if you're going to have a stay or pay agreement, and make sure that you're following the law. Again, as I said, these will be challenged in court for the next couple of years, and we'll see if the board has the legal support of the courts in terms of these far-reaching decisions that interfere with non-compete agreements and stay or pay agreements. In the stay or pay agreement case, the board did outline sort of areas in which they might be legal. And so again, we can't get into a deep dive on that here, but I would urge you to check out that case. And I actually wrote a blog on it, which is on our website. So there's some shameless self-promotion there for you. All right, let's go on next to, let's see, get the slide to move. Okay. Another issue with non-competes, of course, are the related types of agreements that many employers use: solicitation and non-solicitation agreements. These fare a little better in state legislation and also in the courts, although there are state statutes that impact solicitation and non-solicitation agreements. These are typically agreements that employees sign that if they're going to leave and they're involuntarily, or they voluntarily terminate, sometimes involuntarily, depends on how they're written, they agree not to solicit clients or customers, and also agree not to poach co-workers to go to work for a new company. These are generally fare better in the courts because they aren't seen as interfering as much with employees' ability to get a new job or to start a new business or whatever the case may be. But there are still state legislatures that have interfered with the enforcement of these. For example, in Illinois, you can't have one of these if an employee makes less than $45,000 a year. So there are some problems with them. Some courts are hostile to them. Generally, at least before the NLRB's latest decision, if they were forfeitures of benefits as opposed to other types of monetary penalties, they would fare better. But these are now all in question as well. The reason I added tortious interference claims is many times when we see either a non-compete or a non-solicitation agreement, and oftentimes they're together, the employer to whom the employee goes has to be careful, because some employers, where the damage is significant if an employee leaves, will oftentimes sue the employer to which the departing employee is going for tortious interference with a contract, meaning that that's a fancy term in the law that for a claim that the new employer interfered with the departing employee's relationship with his or her employer, and thereby the employer is damaged. So in any analysis you do as to whether or not you want to use a non-compete or you want to use a non-solicitation agreement, keep in mind that there is a risk if you're the acquiring employer of a tortious interference claim under the right circumstances. So the whole area really is an area that demands a lot of specific legal advice if you're going to employ these techniques. Many of my clients have just abandoned non-competes and non-solicitation agreements altogether. But that's a choice you have to make in consultation with your counsel. I have on here confidentiality agreements. These fare much, much better with the courts. These obviously are agreements where a departing employee agrees to keep anything of value that he or she learned or had access to or acquired while working for the employer confidential. Trade secrets, and it doesn't just have to be trade secrets. Any type of proprietary information is protected by confidentiality agreements. These are largely upheld by the courts because most employers, if not all, have significant protectable business interests in their confidential information. Again, whether it's trade secrets, whether it's customer lists, whether it's other types of proprietary information, IP, any type of information that has value because it's confidential can be protected by confidentiality agreements. And we don't see many cases challenging these or more importantly, voiding these types of agreements. So I'm a firm believer in confidentiality agreements. And I think if you're going to use them or you have them in place, you have less to worry about from the legal standpoint than with the other types of agreements that I've addressed. Okay, what's going on with the National Labor Relations Board? Now, why do I talk about this? I talk about this because most people know, some don't, that whether or not you have a union in the workplace, if you're a private employer, the National Labor Relations Act applies to you. You don't have to be organized in your workplace to be subject to the NLRA. And the NLRA contains what we call Section 7, which are all the rights regarding collective bargaining that employees have. And over the years, both in Republican and Democrat administrations, these rights continue to expand. Not surprisingly, when Democrats are in office, the NLRB, National Labor Relations Board, is more pro-employee. And again, not surprisingly, when Republicans are in office, the NLRB tends to cut back on some of the precedent that is set by the prior boards. Over the years, I've been doing this almost 50 years now. It's like watching a ping pong game with the NLRB, depending upon who's in office. Now, generally, the terms of the board members overlap administrations, so any change is slow. But we have seen, certainly during the Biden administration, a very aggressive expansion of employee and labor union rights, again, some of which are tangled up in the courts. But one of the most interesting developments is we had a couple of United States district courts that have held that the NLRB is not constitutionally constituted, if you will. So that now we have at least one district court that says that they can't act because they're not constitutionally properly appointed. Then we have another district court, at least, that says no, they are. Well, now the case is before the Court of Appeals, and we're in the Fifth District Court of Appeals, or Fifth Circuit Court of Appeals. We're watching that case very closely to see whether or not this legal concept of that the board is not constituted legally has traction. Based upon the report I saw, the Fifth Circuit oral argument, it's doubtful that the court is going to hold that the NLRB is not constituted constitutionally, if you will. But we'll see what happens. If they find that the board's appointments are not constitutional, it's going to throw a huge wrench into the works of the NLRB. And I'm not. It's an interesting theory, but I don't think it's really going to get legs. More important, I think, is the NLRB's decision that was made that consent agreements are no longer valid. These are agreements that are reached by employers and employees without essentially the participation of the board and the board agents at the regional level. Those are no longer valid. So if you're going to settle an unfair labor practice charge, for example, it has to be with the participation of the regional office and ultimately the board. Another issue that came along was the case of Starbucks versus McKinney, which is a case that made it more difficult for the NLRB to get an injunction during the pendency of an unfair labor practice charge. The Supreme Court has required that the sort of customary requirements for a preliminary injunction apply, that there aren't special rules that make it easier to get an injunction if it's the NLRB seeking an injunction during the pendency of an unfair labor practice charge proceeding. So if there's a dispute and the board wants to get an injunction against the employer to either keep things the way they are during the pendency of the case or to stop something the employer was doing or not doing, the bar is a little higher than it used to be. And it's a technical thing, but it has a huge impact on the number of injunctions that are sought by the NLRB against employers during the pendency of unfair labor practice charges. So we're keeping an eye on that, and it helps employers defend these cases a little better by holding the courts to traditional elements of obtaining a preliminary injunction as opposed to a little lower standards that the courts were tolerating for these prior to the Starbucks versus McKinney case. You can't really call anymore the Starbucks case when it comes to labor law because there are dozens of Starbucks cases making their way through the courts in the NLRB every day. Okay, what about the EEOC? Let's talk about one of our favorite federal agencies. Each year, the NLRB telegraphs what its strategic initiatives are going to be for the coming year, and that's what you see on this slide. For a couple of years now, the strategic focus has been and continues to be artificial intelligence. The EEOC is very mindful of what they perceive to be the dangers of discrimination in using AI, especially in recruitment and the selection process for employees, but also assessment and evaluation and all the areas that we're familiar with in HR when onboarding an employee or evaluating a candidate. The EEOC is very concerned that there are biases built into AI that can have an impact on protected categories under Title VII of the 1964 Civil Rights Act. They publish a lot on this. You can go on the EEOC website and get all sorts of information about its strategic initiative with regard to AI over the last couple of years, and this is going to continue into 2025 because as AI continues to improve and we can do more things with AI in the employment context, the EEOC is going to be looking over our shoulders to make sure that the application of artificial intelligence in the employment arena does not discriminate against the categories of employees that are protected under Title VII. So this is one to keep an eye on. And it's, but the EEOC is very transparent about it, so you can learn all you need to learn about on its website. However, that should not discourage you from consulting your attorney. More specifically, the EEOC has announced 3 other areas of its focus for 2025. One is the Pregnant Workers Fairness Act. Been a lot of activity from the EEOC in this regard. Much to their credit, they're holding lots of informational seminars on the PWFA, what it means, what it provides, how it's going to be enforced, the issues with it. And for those of you who aren't familiar with the Pregnant Workers Fairness Act, it primarily treats pregnancy the way you would treat a disability, requiring an interactive process, reasonable accommodation, and I frankly have not seen in my practice much litigation or claims over pregnancy discrimination. It was already illegal under Title VII, but now the PWFA has kind of moved it into the realm of how we handle ADA cases, interactive process, reasonable accommodation, undue hardship considerations, and the like. Many states have already legislated in this area. We have it already in Illinois, for example, but now we have it on the federal level. And again, there's plenty of guidance on it from the EEOC, but that's no substitute for getting sound legal advice. So the PWFA is going to be a big area of strategic focus for the EEOC in 2025. Not surprisingly, so is the ADA. The ADA, which has been in effect since, well, it was enacted in 1990. So it's been around for a long time, and generally, employers have learned how to successfully negotiate the ADA, although there's still plenty of litigation under the ADA. And what the idea of the strategic focus for 2025 with the EEOC is they just want to continue to be diligent in advancing the cause of disabled workers' rights, especially in hiring. The ADA over the years really hasn't turned out to be lived up to the promise we had hoped when it was enacted that it would enhance hiring of disabled persons in the workplace. So the EEOC is on top of that. Again, there's lots of information on their plans for 2025 with regard to enforcing and educating about the ADA. EEOC and the Department of Labor have specific divisions addressing disabled workers, and they do a good job of, in my opinion anyway, of advocating for disabled workers. And as all of you know, if you've dealt with ADA claims in your workplaces, they can be complicated and they can be difficult and they can be nuanced. And, you know, proving undue hardship is extremely difficult. But there's a lot of guidance. And again, consult your legal counsel when you have issues, but this is going to be an area the EEOC is going to be paying attention to for 2025. Along with that, the EEOC has made it clear that with regard to the enforcement of all of Title VII, vulnerable populations will be their one of their focuses for 2025. And by vulnerable populations, of course, they mean disabled, especially those with neurodivergence population, and you know, and again, the normal areas of vulnerable population, age, for example, it's one I strongly support, and the other vulnerable populations. And if you take a look on their website, they have a link to their strategic initiatives for 2025, and vulnerable populations, both the ones that you would normally come to mind, but also disabled, older, you know, less educated, you know, folks who are typically vulnerable to discrimination and exploitation in the workplace are going to be one of their focuses. Now, one of the questions that sort of looms over the EEOC and the NLRB for that matter is the effect of the Loper decision. Now, let me talk a little bit about that. Those of you may be aware of this, but the Loper decision is a U.S. Supreme Court decision from last term in which the Supreme Court held that what was called the Chevron doctrine has been abolished. The Chevron doctrine was that for administrative agencies that implement congressional legislation, like the EEOC, the NLRB, the EPA, the FCC, all the alphabet agencies, there used to be, under the Chevron doctrine, the courts would give deference to the legal determinations of these agencies. So in other words, if they came out with an interpretation of the enabling statute, the courts would defer to that in most cases. Well, the Supreme Court said that that was essentially an unlawful delegation of authority by Congress. So now the courts are charged with the determination of what a statute means, and administrative agencies are no longer entitled to deference for their interpretation and the rules they enact pursuant to those interpretations. So that calls into mind, for our purposes, rulemaking by the EEOC and the NLRB, and what effect this Loper decision is going to have on rulemaking of those two agencies, plus all federal agencies. Now, EEOC does engage in rulemaking, as does the NLRB. I don't expect it to have much impact with the NLRB because primarily its rulemaking is procedural stuff. So I don't see that as having a big impact. Their cases are already subject to review by the federal courts, and the Loper may have some effect with regard to the deference given, but the federal courts have not been shy in disagreeing with the NLRB. EEOC makes rules, though, that are more substantive. So I expect to see challenges to some of their rules in the future under Loper, and we'll see how that works out. But I thought everybody should be aware that the courts have been charged by the Supreme Court with no longer deferring to the legal interpretations of statutes by administrative agency. And this may have a beneficial effect on business as it plays out. I mean, the case isn't even a year old, so we'll have to watch and see how it's applied in the lower courts and in future Supreme Court cases as well. Okay. I have a section here about Illinois law changes that are reflective of national trends. So I'm hopeful that those of you who aren't in Illinois can find something useful here, because we are seeing several trends nationally in state law, which are reflected in what's going on in Illinois, where I primarily practice. One is enhanced whistleblower protection. Most states have some form of whistleblower protection. Sometimes it's only for public employees. Other times it's for both public and private employees. So be aware that whistleblower protection is expanding across the country. And in our statutes, typical of most of the statutes around the country. As you see here from slide number 6, there are definitions that are important in terms of who's covered by it, but it's typically what you would expect as the definition of employer and employee. More importantly, I should say, is the substance of what it protects. These statutes prohibit retaliation against employees, and it's important to look because they do differ in some ways across the states, but Illinois is pretty typical. It prohibits retaliatory action of any kind against employees who disclose or threaten to disclose to a public body, and that's defined as the state, units of local government, conducting an investigation, or in a court, an administrative hearing, or any other proceeding initiated by a public body, information related to an activity, policy, or practice of the employer. So it's expanded the agencies for which a whistleblower gets protection by blowing the whistle. And what is whistleblowing? Well, it's the disclosure or threat of disclosure to a public body of any of these practices or policies or activities in which the employee has a good faith belief that the activity, policy, or practice violates state or federal law, rule, or regulation, or poses a substantial and specific danger to employees' public health or safety. It's broad, and what triggers it is that the employee, has a good faith belief that this activity, policy, or practice violates law or presents a substantial and specific danger to health and safety. I'm telling you, as an attorney, that is a huge and broad category of protection. And a good faith belief, which is generally a matter of fact, just invites litigation. And we have a fair amount of litigation in Illinois under the Whistleblower Protection Act. It's often joined with other types of claims, but when an employee is retaliated against or terminated, but this will increase the litigation, no question in my mind. So, and an adverse employment action is pretty broad. The statute has now picked up the definition of an adverse employment or retaliatory action that the U.S. Supreme Court uses in Title VII cases, which is that a reasonable employee would find it materially adverse if it could dissuade a reasonable worker from disclosing this information, which again is, I think we all pretty much have a grasp on what a retaliatory action is. As many of you may know, the Supreme Court has loosened up the definition of an adverse employment action, which now it doesn't require much to trigger the protection of Title VII. And we're seeing the same trend here with the Whistleblower Protection Act, at least in Illinois, and I think nationwide for those states that are amending their statutes. So this is one to be mindful of. It's no longer something that we just don't worry about. You need to familiarize yourself with this because, again, we have a lot of litigation under the Whistleblower Protection Act here in Illinois, so it behooves you to be familiar with the statute. And again, get good legal advice, rely on your HR folks to help you navigate this when something like this comes up. I have seen these types of claims partnered with discrimination claims. I have a couple of cases, at least, where the employees who were claiming that they were retaliated against and forced to resign have said that one of the reasons was they were exposing unlawful conduct in the workplace, i.e. discrimination, and other related things that they think led to their termination. So this has now worked its way into the things that we have to consider when taking action with employees, and with the help of your counsel and your HR professionals, you can navigate this. Although, as a lot of my clients have lamented over the years, it doesn't keep someone from filing a claim or suing you. Let's see if there's anything else significant that I want to. Oh, yeah, our statute has added immigration authorities as it says here, that as a form of potential retaliatory action under the Act against a whistleblower is turning them into immigration authorities, which is a new twist to our statute. But if you're familiar at all with Illinois, not surprising. Let's see. Well, then it gives a definition of 3 rather limited categories of what isn't retaliation. That's primarily those things which are authorized by law. Okay, here's one that we've seen exploding across the country. In our state, it's an amendment to the Illinois Human Rights Act, but other states have also enacted this in different forms, and it's the concept of family responsibility discrimination. That is illegal. It's a new protected category that prohibits discrimination, all forms of discrimination, including retaliation, of course, based upon an individual's actual or perceived family responsibilities. Now, because it's new, I'm really looking forward to how this is going to be fleshed out over time, and what the cases will look like that make it through the system, so we have a better understanding of what facts constitute a violation of the family responsibility discrimination prohibition. In our statute, family responsibilities include personal care of covered family members, as you can see here, meaning activities to ensure that a covered family member's basic medical, hygiene, nutritional, or safety needs are met, or provide transportation to medical appointments. And it's kind of broad, especially because it includes provision of emotional support to a covered family member with a serious health condition who's receiving inpatient or home care. And covered family members include, this isn't quite as broad as our bereavement statute, but it covers children, stepchildren, spouse, domestic partner, pater, sorry for the misspelling, sibling, parent, mother-in-law, father-in-law, grandchild, grandparent, or step-parent. So it's broad. And again, it's new, so it'll be interesting to see how this is applied by the administrative agencies and the courts. Now, interestingly enough, the statute provides that nothing is to be construed obligated an employer to make accommodation or modification to reasonable workplace rules or policies for an employee based on family responsibilities, including accommodations or to timeliness, work performance, and benefits, as long as the rules comply with the Act. Also, you're not prohibited from enforcing reasonable workplace rules or policies related to leave, scheduling, productivity, attendance, absenteeism, timeliness, or work performance, but you still have to comply with the Act in regard to the enforcement of those things. So this is one we're going to have to see how it works out. And also have to see what the rules are that are promulgated by the various administrative agencies that will enforce this type of new anti-discrimination prohibition. But I don't think it's going to have an enormous impact, but you might be thinking reasonable accommodation when you're confronted with these sorts of demands or claims. Another trend that we're seeing is protection against what the statutes call reproductive health discrimination. Certainly in Illinois, to the Illinois Human Rights Act, the legislature added reproductive health. It says deconsider, that's a misspelling, decisions. This is what I get for borrowing slides from people. Reproductive health decisions are now protected from discrimination. Those are defined, as you might expect, decisions regarding use of contraception, fertility or sterilization care, assisted reproductive technologies, miscarriage management care, healthcare related to continuation or termination of pregnancy, or prenatal, intranatal, and postnatal care. So it picks up pretty much the range of reproductive health decisions, including, as is obvious, abortion and other types of termination of pregnancy. So you can't discriminate against employees on the basis of their reproductive health decisions, assuming that you know. And that's something that is, again, becoming a national trend. Okay, what else? New E-Verify requirements. E-Verify has always been controversial. Some employers follow it, some don't. The government is sort of, is ambiguous about it. But be aware that in Illinois anyway, and other states, new E-Verify requirements have been added to, in our case, the Statute of Privacy in the Workplace Act. Primarily, we have to be prepared to comply with these procedures. If after using E-Verify you find a discrepancy, or if you get a governmental notice of no match, you have to provide the employee with the specific documentation, how they can fix it, an explanation that they have a right to be represented during the process, and as it says here, an explanation of other rights the employee may have in connection with the employer's contention that the employee is not authorized to work. Let's see, what is significant here? is, again, there's an anti-retaliation provision, which we have in every statute that protects employees. You can just assume that any statute that impacts your employees and protects rights or grants them rights has an anti-retaliation provision. And often, retaliation is a separate violation of the law, as opposed to, having to prove an underlying discrimination claim. It's illegal to retaliate whether you discriminated or not. So you can't take any adverse employment action once you get the notification that there's a problem with E-Verify, and it just has these notice requirements that you have to go through. But the word is Illinois is going to enforce this strictly, as I'm sure other states will. So again, be familiar. There are a lot of secondary sources to help you understand on the websites for these agencies. But again, that's no substitute for good legal advice with regard to compliance, especially if in the hiring process you use E-Verify, which, as I indicated, many employers do. So you want to make sure you do it right and be aware of the state law implications for the use of E-Verify. Excuse me. Okay, let's see. There's just some technical stuff I want to move on to. Here's a popular one. A lot of states are beginning to adopt disclosure of pay scales in job posting. Businesses have fought this trend hard, but they're losing. Even under federal labor law, National Labor Relations Act, that's long been the board's position, which has been upheld by the courts, that employees can share payroll information with each other, even though you might deem it as confidential. So amendments to the Illinois Equal Pay Act, and again, this is a national trend, is that in job postings for here in our state, at least 15 employees, you have to disclose pay scales and benefits for specific jobs so that candidates will know what the pay scales are. And it's also a way of trying through the back door to prohibit unequal pay, especially on the basis of gender, but also race. And as it says here, it's unlawful for an employer with at least 15 employees to fail to include the pay scale and benefits for a specific job in a job posting. Now, they have given us a little easier way to implement this, which is we can satisfy the requirement by including a hyperlink in the job posting. So it doesn't have to be the job posting itself, but just access by the candidate or the applicant to see what the pay scale and benefits are for that specific position they are considering. And it defines pay scale and benefits broadly as a wage or salary range, description of benefits or other comp, bonuses, stock options, other incentive. And if you do have a pay or stay agreement, that should be disclosed as well. But I think those are going to be, we'll see how those fare in the courts. Okay, here's a thing that I've had a lot of questions about from employers. The amendments do not just apply to positions performed in Illinois. It's positions that will be physically performed, at least in part in Illinois, or physically performed outside of Illinois, but the employee reports to a supervisor, office, or other work site in Illinois. And this has caused confusion and consternation by employers, especially in our area in Missouri, what is the extent to which they have to comply with this? And we're navigating that now. And of course, the Illinois Department of Labor will issue rules implementing this, and we'll have to see how that's going to go. But I take a very conservative approach because I want to keep my clients out of trouble and not get pulled into the administrative machinery or courts. And so I've taken a pretty liberal interpretation of the statute. because it's, you know, I mean, it's a national trend. So, and it's just a matter of time before we have to do this across the country. There's some other technical, now important, especially to temp agencies and other companies that provide employees. You'll see in the last bullet point, if you use a third party to announce, post, publish, or otherwise make known a job posting, that is also covered. So that the third party has to include that information in the job posting or in the recruitment. So that's one to keep an eye on. Again, rely on your HR professionals to help you with this, as well as your labor and employment counsel. Oh, okay, before we get to questions, I did want to leave a little time for questions. I was asked to mention to the participants here that Missouri has enacted a paid sick leave time law. Last year, or maybe it was earlier this year, but I think it was last year, when we talked about employment trends, Illinois had just enacted the Paid Leave for All Workers Act, which provided 40 hours of paid leave, no questions asked, for full-time employees, and pro rata for part-time employees, earning an hour for every 40 hours worked. So Missouri, I guess because it's too close to Illinois, caught the bug, and it enacted what's called an earned paid sick leave time law. It takes effect May 1st of 2025, so there's time to get ready for it for you employers who are in Missouri, and for those of us who advise Missouri employers. So it begins May 1, 2025, or when employment commences, whichever is later. And essentially, in a nutshell, it provides that for any employers with 15 or more employees, employees shall accrue a minimum of 1 hour of earned sick time for every 30 hours worked. So it's a little more generous than the Illinois statute, because it's 1 for 30 as opposed to 1 for 40. Employees will be limited to using no more than 56 hours of earned sick time per year. If you have fewer than 15 employees, it's again 1 hour for every 30 hours worked, and it's a limit of 40 hours to be used during the year. Like the Illinois statute, instead of accrual, you can front load. Now in Illinois, if you front load, you can't take any of those back if the employee leaves before he or she has used up the leave. So, but it's a lot easier to administer. So there are pluses and minuses of front loading or using the accrual method. And again, Illinois says these 40 hours under the Paid Leave for All Workers Act can be used for any reason or no reason at all, and the employee does not have to tell the employer why the employee is using leave. In Missouri, the statute provides that this time can be used, may be used, I should say, for what you might expect: illnesses for the employee, care of family members who have illnesses, business closures due to public health emergencies. It's interesting. And as is the case with many states, absences necessary due to domestic violence, sexual assault, stalking, and seeking medical care or other professional services for those events or actions. When leave is foreseeable, the employee has to make a good faith effort to provide notice. Employers may require reasonable documentation if the more than 3 days is used at a time. Now, carryover is always an issue with these statutes. So under the Missouri statute that takes effect in May, up to 80 hours can be carried over year to year, subject to those maximum use requirements I mentioned earlier. And of lieu of carryover, an employer at its choice may pay out the earned sick leave time at the end of the year in order for the leave not to carry over. So it's important to know that Missouri now has joined the ranks of mandatory earned paid sick leave time. And again, that is a national trend. The differences are what you can use it for. Like in Missouri, there are requirements for the use. In Illinois, it's those 40 hours have to be used for anything or anything, and the employer doesn't have to tell the employee doesn't have to tell the employer why. Okay, so we have 4 minutes for questions if anybody has any. I'd be more than happy to respond to any. Summer, do we have anything in the chat?
At the moment, I don't see anything coming in. I personally have a question though regarding E-Verify, and really, I guess I've looked into this, researched it, and want to know really what the difference is with E-Verify and these new rules. We run a lot of E-Verifies here at higher level, and that really kind of explains the process that we follow. So I guess I still have a little bit of confusion on what's the actual change.
Well, it really, if you look at the changes that were made, they're really process changes, like no adverse action based upon a receipt of information that there's a problem with E-Verify. But I'm not sure that people weren't doing that already. So I think it was, as I read it, it was to shore up the protection of employees when there's a problem with E-Verify, and keeping employers from just, not hiring them or, retaliating or discriminating. I think as I read it, what it did was to just sort of recognize and enhance and require the procedural protections for employees. But I don't sense, and I don't have a lot of experience with E-Verify, but I don't sense that there were really substantive changes with these new amendments.
Okay.
So I think you're right.
So I guess another question, as you said that, if it comes back that a person is not verified to work in the U.S., but you have already started to employ them, does it keep you from taking action at that point?
Not after you jump through all the hurdles that the law requires. So when you do the documentation, they get a chance to respond, and you got to share it with them. And there's so many days you have to do this. If they can't correct it, and it shows that they really aren't eligible, yes, then action can be taken. But it's kind of almost like the criminal background check stuff that we've had for a few years, where you make an offer of employment, then you got to jump through all the hoops. If a criminal background check comes back that has an impact on the job, then you can withdraw the employment. It's just more procedural hurdles to get over, with the idea that it's protecting the potential employees a little better.
All right, I don't see any more questions coming into the chat at this time. John, thank you for joining us today. Everyone, we will be emailing the recording of this presentation out we wanted to go ahead and let you know of some other upcoming HiNotes that we have scheduled. We will be going over the Missouri 2025 Proposition A, which covers paid sick leave, changes to minimum wage that will be hitting at the beginning of the year, and then of course May 1st for that paid sick leave update. And then we will be covering the very next day, December 11th, on handbooks and what information needs to be in your handbook, what policies maybe need to be reviewed and updated based on different changes that have taken place. And we hope you are able to RSVP and join us for those sessions. Thank you, John, for attending, and we will talk to you soon.
Well, thank you, Summer. Thanks, everyone, for participating.